university was not established by the minority community, which is the finding in Basha. Then, Malads, in any case, it was not administered by the Muslims. That's the other level. That's also the finding in Basha. Then, in any case, it is not a minority. That's the third level at which it was argued. And fourth, that it is an institution of national importance. So it's lost its minority character, even if it had any. These are the four broad, Malads, submissions that have been made. And I think, Malads, with respect, greatest respect, that we are going a bit astray constitutionally. What does Article 30 say? All minorities, whether based on religion or language, shall have the right to establish and administer educational institutions of their choice. Let's pause here, Malads. If I have not established as a minority, I cannot administer. So I have a right to establish. That's what 30 says. If I have established, then I have a right to administer. So Article 30 gives me a right to administer. It doesn't say that the administration must be in my hands or in Muslim hands or Christian hands. That's not the meaning of Article 30. Administer of my choice, rights to administer of my choice. I have a choice, not you, not the government, but I must establish it. Unless I establish it, that right doesn't accrue to me. And the right that accrues to me is the right to administer the institution as I please, of my choice. Well, let's take, for example, any minority institution in this country. Well, I don't think any minority institution in this country is administered by minorities. You apply the wrong test, you'll get the wrong answer. Take St. Stephen's. How many teachers are minority? Not even 5%. Administration. How many are filled with Christians? Not more than 5%. Students. How many are Christians? I don't know now, Malads. Used to be 9%, 14%. Well, what's the relevance of that? This whole numerical argument is only irrelevant to Article 30. So, Malads, kindly take the statute. Take St. Stephen's College in the context of Delhi University statute. The syndicate, Malads, I am not part of that syndicate. I'm not part of the executive council. I'm not part of the academic council. That means I'm not a minority institution. What tests are we applying? Never before in the history of this court have these tests ever been applied. That's why there are no judgments cited, Malads. So, Malads, the mistake in Basha was that when Basha said that you have not established this university as a minority, then the council argued, but I am administering it. And Basha said, you're not. That's not the test. So, Governor General does this, Rector does this, Malads. I want to ask myself a question. If I am enacted by an act of the Central Legislative Council, Malads, will there not be a structure by which somebody has to see that I'm not maladministering? Take our constitution today, I set up a minority institution, Malads. When I'm setting up that institution, will the chancellor of the institution, which has nothing to do with the minority, not have the right to inspect? He'll have the right to inspect. He'll have emergency provisions. He may even have the right to take over. Administration doesn't mean maladministration. So let's start with the proposition that I have a right to administer. Your Lordship asked a very fundamental question, but the 81 Act is not a status quo ante. The Lordship is right, but I accept it. I accept it. I'm not a minority institution. I still am. That's my choice. And that's the other mistake that we are making, which is an error of law. I don't have to be administered either by the Muslims or the Christians when it comes to minority institutions. You won't have Christians or you won't have Muslims, Malads, who are educated at that level to be in every. So, Malads, TMA Pi had 4 tests. Para 50 of TMA Pi set up 4 tests. What do you mean by administer? Malads, just kindly come. I've done a rejoinder, Malads. It's also part of the kindly come to note 1G. Yes. Page 3 of note 1G. That's why, Millets, my learned friends, when I argued this in the beginning, never answered that question. Because 1906 regulates minority institutions as much as it does majority institutions. Regulation does not mean destruction of the right. So if the chancellor is appointed, Millets, by the president, it doesn't mean that I've lost my right as a minority institution. So let's kindly see the TMA Pi para 50.
Where do we get it?
Well, that's my volume 1G, Malat.
At page?
Page 3.
Yes.
Ambit of right to administer was set out as including the right to admit students, subject to an objective and rational procedure of selection. No problem. That's the institution as the right. The minority, once I establish the institution as a minority institution, I have a right to admit students in accordance with procedure which is fair and transparent. Perfectly good. I'm doing that in Jamia, in AMU. 2, set up a reasonable fee structure. The institution is doing it. 3, to constitute a governing body. We have a governing body. It doesn't say governing body, we must have all Muslims, or governing body, we must have all Christians. Where is it said? Where is that test? 4, to appoint staff. Appoint staff. Normalists. The university says, if you want to teach in AICTE, the teacher must have these qualifications. They abide by that. But the right to choose the teacher is mine. In Delhi University, the university provides that if you want to teach economics, the person must be a doctorate or whatever. The choice of which doctorate will teach is mine. But the university will set the standard. That's what it is, to appoint staff teaching and non-teaching. Standards set by the institute, by the structure of the university. And 4, to take action if there is dereliction of duty. These are the 5 indicia of administration. That's 11 judges. Now test this in the context of what Basha said. Now kindly come to Basha for a minute. 3A. Yes. I'm sorry, page 16 of Basha at volume 3A, page 16. Annulus praesitum GNH. Wrong argument, therefore the wrong answer. It's not a twin test. Am I administering? That's not the test. And we have all, Maras, throughout these days, we've been arguing about, show me if you're administering. It's not required by 30. You'll never get that, Maras. That way, there will be no minority institutions left in this country. Apply this even to the institutions after 2005. All the provisions that are here in the 81 Act are all there in 2005. Inspection, emergency, a final approval, all that. I've got a chart, I'll show it to you. So what are we trying to do? Apply a test which will destroy the entire minority structure of education.